Honorable Supreme Court, I like to present in the Supreme Court of India, Criminal Appellate Jurisdiction, Criminal Appeal number 143 of 2022, the State of Uttarakhand Appellant versus Sachin Singh Rajput. The present appeal has been preferred by the State of Uttarakhand against the order dated 11/12/2018 passed by the High Court of Uttarakhand at Nainital in Criminal Appeal number 110 of 2016, by which High Court has allowed the said appeal preferred by the respondent, that is accused, and has held the culpable homicide in the instant case of not murder, and consequently has converted the sentence of life of imprisonment to 10-year rigorous punishment. The key facts of the case here are as follows. The respondent, wherein original accused, was charged and tried for the offence punishable under section 302 and 10 IPC, that is 103 of BNS, for having committed the murder of one Virendra Singh. On 26/11/2014, the entire village was celebrating Mehndi ceremony on the occasion of wedding of the Anil. In ceremony, the entire village participated, including the deceased Virendra Singh and the accused Sachin Singh. In the night, it was the first scenario. Some altercation took place between the deceased Virendra Singh and the accused Sachin Singh Rawat. But due to intervention of the villagers, the matter did not proceed further, and the cold-blooded murder by the accused was somehow delayed and the victim saved at that time. In the second scenario, the accused has planned the murder and prepared the murder weapon. In the night, some altercation took place between them. After the dinner, about 12 a.m. in the night, the accused attacked Virendra Singh by giving him blows by the danda, that is pakhadiya in a local language, a rough piece of wood which he was carrying. The blow was on the head of the deceased. Virendra Singh, after the brutal attack on him, ran toward his house for safety to save himself from such life-threatening attack. The accused ran after the deceased with the danda in his hand, and the deceased sustained multiple injuries on his head, which is very vital and which caused his death. There was a skull fracture and the frontal wound on the left side of the skull. The complainant, who was the wife of the deceased, tried to rescue her but failed. Meanwhile, several blows were given to her husband. The mother-in-law of the complainant, that is Geeta Devi, also came to rescue but could not rescue him. Due to grievous injuries, Virendra Singh fell unconscious. The deceased was initially taken to Dr. Sharma, who resided at the Ghansali, which was only few kilometers away from, considering the condition of the injured. He was referred to the Mahan Indres Hospital at Dehradun, where he was operated upon after a few days. That is on 5/12/2014. Virendra Singh passed away. The wife of the deceased then filed the FIR against the accused, that is current herein respondent. Investigation was done by the police officer in charge of the police station. During investigation, police officer recorded the statement of the eyewitness, including the complainant, that is the wife of the deceased. The investigation officer collected the medical evidences, including post-mortem report, etc. On conclusion of the investigation officer filed the charge sheet against the accused for the offence punishable under section 302 IPC and 103 BNS. 14 prosecution witnesses were examined, that is, many of them were eyewitnesses, including the complainant, that wife of the deceased, and moreover, Pankaj Arora as PW11, who has operated the deceased, After the closure of the evidence of the prosecution side, further statement of the accused under section 313 CRPC, that is now 351 BNSS, was recorded. Thereafter, an appreciation of the evidence and believing the evidence of the eyewitness and considering the nature of the injury sustained by the deceased, the trial court, that is session court, held that the culpable homicide was murder and thereby convicted the accused for such cold-blooded and pre-planned murder, and thereby accused is convicted for life imprisonment sentence. The accused preferred criminal appeal number 110 of 2016 before the High Court by the impugned judgment and order through the High Court has believed the evidence of the eyewitness, including PW1, wife of the deceased, that is present at the scenario. However, High Court still has held that culpable homicide did not amount to murder solely on the ground that it is not cold-blooded murder, rather it is a sudden fight which ensues in the heat of passion between the two. But the testimonies of witnesses and evidence raise a serious question on such order by the High Court. We hereby humbly request the Honorable Supreme Court that the fact of circumstances of the case of the High Court has committed a grave error in holding that the murder of the deceased does not amount to culpable homicide. And the High Court has erred in observing and holding the case that case would fall within the fourth exception under section 300 IPC, that is 101 of BNS. It is prayed by the justice which the deceased deserved. We humbly pray to set aside the impugned judgment and order passed by the High Court questioning and setting aside the conviction of the accused for the offence, to restore the judgment and order passed by the trial court convicting the accused for the offence under section 302-103 BNS and sentencing him to life imprisonment for such cold-blooded murder in the occasion where two lives were getting tied for 7 upcoming lives, but the happy wedding is converted into a crime scene. Thanks.
Which of the following points to relate to this case? I am trying to attention of that point. In the Honorable Supreme Court of India, feeling aggrieved and dissatisfied with the impulse and judgment and order dated 11/12/2018 is passed by the High Court of Uttarakhand at Nainital in the criminal appeal number 110 of 2016, which the High Court has allowed to set appeal prepared by the responder accused has held that culpable homicide is that instant case is not a murder. Point to be noted below. Instant case is not a murder, and converted that sentence from life imprisonment to 10-year rigorous imprisonment. The state of Uttarakhand has which means saying that so High Court not a declare of murder. They are by mistake of that death, and reference quote to the reference by the Nainital High Court under sections 300 exceptions number 4. According to BNS, under sections 101 exceptions number 4, and recently, as the case was exclusively trial by the Court of Session, the case was committed to the session court is where the accused was put to the trial. Accused are also attend to the session court, and because they are not guilty, not pre-planned murder, just suddenly impalpable incidents and beating and fighting to each other and serious injury that was in the day, not planned murders. According to prosecution, sir, it is not a planned murder, sir. Is pleaded not a guilty and we have is claimed to be tried by the trial court for the offence punishable under sections 103 of BNS 2003 or 23, sir. Mr. Virendra Singh death are approx after 10 days. The death reasons are not clear, sir. That is true. Fighting to both are, but not reason are not clear. Death is a fighting incident, another incident during treatment and then also operations. So death by the grievous injury, beaten activity accepted, and doctoral negligence also, because doctor are done the operations is during the hospitalized of the patient, which means these points are completely doubtable also, sir. Is feeling aggregate and despite with the judgment and order of the convictions passed by the trial court and sentencing him the undergo life imprisonment, the accused performed criminal appeal number 110/2016, sir, before the High Court by the judgment and order through the High Court has believed the evidence of that eyewitness in PS prosecution's witness first, sir, the wife of the deceased, however, has held that culpable homicide did not amount to murder. Slowly, on the ground that it is not a cold-blooded murder, sir. Rather, it is a sudden fight which ensued in the heat of the patients between the two as the result of its sudden fires in the marriage ceremony, and that the weapons used Patyar, which is rough piece of wood, is before cannot be said that there was any intentions on the part of the accused to kill. Is committed to the murder of the deceased, and rather from the sections would fall under the fourth exceptions of sections 101 of BNS 2023. After holding so, and after attaining the fine of the murder to one of whomever homicide amount to the murder, the High Court has converted the sentence. Point to be noted, sir. Converted the sentence from the life imprisonment to the 10 years. This rigorous imprisonment, and High Court is the superior court, sir, than according to trial court, sir. So, very meaningful decisions of Nainital High Court, sir, because High Court is a very prestigious institute of according to Indian constitutions of the state. So that judgment is acceptable, or rigorous imprisonment sir, is very just like a death punishment according to comparison, sir, because rigorous imprisonment including labor and extreme conditions also, and separated one bullet and the cell in the jail cell. Just a one hearing hall only present there and in the jail cell. So already in a 10 year they are punishable complete to whole life and listenable also. So that point is mentionable under sections 101 exceptions number 4 of according to BNS. So that regions is clearly saying that Nainital High Court. If the learning councils is appear on the behalf of the respondent, accused has tried to support, not removable and not fairing and fair is also sir. They are supportable. They are accepted, yes, mistake by mistake that incidents accepted by the accused, but not any intentionally. Support that the imprisonment judgment and order passed by the High Court is holding that the instant case of the Humble culprit is the amounting to the murder invoking is fourth exceptions of sections 101 of the BNS. It is submitted by the elections learning councils is appear of the behalf of accusing is consent reason have been is given by the High Court after considering the surrounding circumstances and other considerations at that whomever culprit is not amounting to the murder. They are already accepted, lower court also and High Court also. Lower court punishment mismatch because like imprisonment is against to the humiliation because humanity because insan born as a person to seeing the life and live to the life and important incidents experience to the own life. One person is completely whole life in particular persons and particular persons to nothing seeing in life. So that is human right point including also by the Nainital High Court. Because as a human, some basics rules are followed in that. Also punishment is an exception according to Indian law, not a necessary. That statement Honorable Supreme Court later on a few days. It is submitted that the rightly observed by the High Court as the weapons used by the accused was the Paktiya, also Danda, which is a rough piece of the wood. It cannot be said that there was any prediction or the intentions on the part of the accused to the kill as committed there the murder of the deceased. Page number 4, sir. Point number 8. It is further submitted that the High Court has its right observation, sir, and held that the incident occurred in the sudden fight in the heat of the patients. On the sudden queries in the Mehdi ceremony, and that the weapons used by the Paktiya or the which used that firewood, not only particular dandas are also firewood. Firewood is primarily where the food is being cooked and where the heat of the patients is accused is pick up the Paktiya and use the some, and therefore the cases would fall under fourth exceptions to the sections 101 of the BNS and section 300 exception number 4 of IPC 1867. It is therefore submitted that the High Court is rightly attacked in finding to the murder one of rheumatoid culpicide is not amounting to the murder, and has rightly converted the sentence from the life imprisonment to 10 years is rigorous imprisonment. Is making the above submit is the prayer to dismiss the present appeal, sir, and continue because 2 or 4 years also they according to High Court punishment are already goes there. So thank you, sir.
So first of all, I would like to extend my humble apology for not getting the real evidences adduced. And the second thing, I would like to, we the prosecution wants to submit it. We want your the permission of Honorable Court to introduce the additional evidence. Sir, the prosecution wants to bring the mind of the court into a one important question regarding the evidences which the prosecution has produced. The first one being the prosecution relies on the combination of oral, medical, documentary and circumstantial evidences supported by the relevant case laws which has been held by the Honorable Supreme Court and various Honorable High Court of this nation. The second being to establish the accused guilty beyond a reasonable doubt, because sir, to establish the accused, sir, it is the primary and prima facie principle of law that if you want to establish the guilt of the accused, then it should be proved beyond a reasonable doubt. But here in this case, the guilt of the accused has not been proved beyond a reasonable doubt because the chain of circumstantial evidence is not completed. Let me introduce the Honorable Court why. The first being the complainant testimony. The complainant will testify on March 15, 2021. The accused Sachendra Singh Rawat assaulted him over a property dispute in Dehradun. He will also state that the accused physically attacked, verbally abused and threatened him with the dire consequences which has ultimately resulted into the death of the victim, satisfying the element. The complainant will also further testify that the incident took place in public place where other witnesses, but it has been nowhere mentioned by the defense that the culpable homicide which the defense was charging with is totally based upon the malicious things which the defense want to state in this point. The second reason being the testimonial live witnesses. The first being Ramesh Kumar, and for seeing the testimony I would like to request the court to please see the printed copy page number 2 which the prosecution has submitted. The first being that Ramesh Kumar, who is also known as the prosecution witness 1, will also confirm that he saw the accused pushing, slapping and abusing the complainant. He will also testify that the accused issued threats to the harm of the complainant, fulfilling the section of 506 IPC also, which relates to criminal intimidation. The second testimonial eyewitness which the prosecution wants to produce, that is Mr. Anil Sharma, who is also known as the local shopkeeper out there. The Anil Sharma will state that he heard the accused using abusive and provocative language against the complainant. But I would like to extend the humble attention of the court to one important case law which has been held by the Honorable Supreme Court in the year 1979, which is Joginder Singh versus State of Punjab, in which it has been categorically held by the Honorable Supreme Court of the India that mere evidences corroborating the complainant version of physical assault is sufficient to establish the guilt of section 323 and 103 of BNS. Sir, I would like to also raise the court attention to one important point out here, that whenever the decision is passed by the trial court and it gets challenged into the High Court, it is very in rare cases that High Court allow the defense and the prosecution to give additional evidences. Here in this case also, no additional evidences was being made out by the prosecution, nor the High Court has given the permission to produce any sort of any sort of the prima facie additional evidences. Because of this, it has been naturally very much evident that the decision passed by the trial court is very much similar to what has been passed by the High Court. The prosecution also wants to submit that merely because the weapon used was lathi, that by itself cannot make culpable homicide as not amounting to murder. It is submitted that the High Court has not properly appreciated and considered the repetitive blows on the vital part of the body. Here, I would like to bring attention of the court that repetitive blows is a conduct which should be appreciated by the High Court, because it plays a very important role to draw the intention of the accused, because in order to prove the murder, the intention of the accused has to be placed, and it has been held by the considerable judgment. The intention of the accused, the intention of the victim is something which should be manifested by the conduct. Here, the repetitive blows by the lathi given on the vital part of the body, head, and multiple injuries sustained by the deceased, it has been proved that there is not any case of no intention. The intention was evidently present in this case. It has been humbly requested by the prosecution that the High Court has also not properly appreciated that after the first incident of altercation between the two at the place of marriage ceremony, due to the intervention of villagers, the matter did not proceed further. However, at about 12 a.m. in the night, the accused attacked the deceased by the lathi which he was carrying, and when the deceased ran toward his house for the safety, the accused ran after him. Here, the conduct of the accused running after him plays a very important role to fulfill the condition of section 6 of Bharatiya Sakshya Adhiniyam, which state about the previous conduct influencing the fact in issue. Reached his house and continued to give several blows. Several blows. Here the conduct of giving several blows also plays a very important role to fulfill the section 4 of Bharatiya Sakshya Adhiniyam, which talks about the conduct which has been done in the same transaction. It is therefore submitted that the High Court has done grievous mistake in observing that holding that the case would fall under the fourth exception to 300 IPC. It has also been submitted by the prosecution that whenever the trial court or whenever the High Court deals with the case, there is no any presumption of section 105 Indian Evidence Act, which is now section 108 BSA. High Court will not presume any sort of general exception here. It has been grave mistake has been done by the trial court in which section 108 presumption is there, which I would like to extend an humble apology toward the trial court as well. It is submitted that the High Court has not properly appreciated the fact also that the main incident of having beaten the deceased was subsequent to the first incident of altercation in the Mehndi ceremony, which also fulfills the condition and the elements of section 6 about the subsequent conduct influencing the fact in issue. It is submitted that by no strength of imagination it can be said that the incident had occurred due to a sudden fight in the heat of the passion upon the sudden quarrel in the Mehndi ceremony. Sir, I would like to also place a very one important and landmark case of the Supreme Court, in which the Supreme Court has also held that, sir, in the case of Subramaniam versus State of Tamil Nadu, which has been held by the Honorable Supreme Court in the year 2009, it is the citation number is 482. The Supreme Court held that the counter FIR filed after an initial complaint must be scrutinized carefully. Sir, here I would like to bring the attention of the court towards the word scrutinized, which means careful examination has to be done. Here the side of the accused has not, the intention of the accused was to maliciously prosecute and mentally harass the victim, and the voluntary causing hurt complainant is also there. So I would like to submit that grave punishment should be given. The second point here, it is not about culpable homicide amounting murder or culpable homicide not amounting murder. It is the justice which should be prevail, because the intention of the accused was not to attain justice, but to mentally harass someone, which basically I request, we the prosecution request from the court should be struck down completely with the absolute and the immediate effect. Thank you.
So, as my colleague has stated that not punishing the accused who has committed such murder, heinous crime and cold-blooded murder with such preparation of the lathi, it is utterly disrespect to the death of the deceased. That if the punishment has not been, severe punishment has not been served to the accused. And I like to explain regarding the point that the defense has taken as a section 4 to the section 300 IPC 101 BNS. There is no scope for exception 4 to section 300, and that is 101 BNS. Sudden fight is not applicable. The High Court has not properly appreciated that after the first altercation between the two at the place of marriage ceremony was subdued due to the intervention of the villagers, the matter did not proceed further and everyone led to peace. However, in the second altercation at about 12 am in the night, the accused attacked the deceased and ran toward his house, attacking him with his lathi. He reached his house and continued to give several blows. It proves that the preparation and premeditation rather than a sudden fight. He has prepared at night and prepared after first altercation and conspired how to kill him at night when no one is there for subduing the fight. The accused had time to cool down after the first altercation at the wedding, but still chose to continue the attack. The High Court has erred in observing and holding the case would fall under the fourth exception of the 300 and 101 BNS of the, as there was no premediation and it was the result of sudden fight and due to sudden quarrel in the mehndi ceremony. Regarding case law in Suren Singh vs State of Punjab 2017 5 SCC 796, it was held that exception 4 does not apply if the accused had time to reflect before attacking, and here is a grave delay. There is two separate altercations. In case of Bhavi Sethi Kameshwara Rao vs State of Andhra Pradesh 2008 15 SCC 725, the Supreme Court ruled that if the attacker continues the initial fight after the initial fight is over, the act does not qualify as sudden fight. And here is the same case. There is two separate point of fights. So the sudden fight does not applicable here, and exception 4 cannot be chosen by the defense. The High Court has failed to properly consider the medical evidences also. Section 109 of Bharati Sakshi Adhiniyam, the burden of explaining the circumstances rests on the accused if they claim no intention to kill, and the postmortem report confirms skull fractures, deep injuries on vital parts of the body, that is head, and skull has 34 stitches and partly broken. It is a very brutal attack. The High Court wrongly overlooked forensic evidences and misclassified the offence as culpable homicide, not amounting to murder. In case of State of UP versus Viren Pratap 2003-15 CC 43, it has been found that striking a vital part, that is head, with force even with blunt object proves intention to kill. That is all.
So, prosecutions is very vast descriptions related to case. But few descriptions according to my point. First is the injury of the skull. Basically, human body structure, anatomy also, histology of human body. Basically, neck of the above of the neck, scales has made up of three bones: parietal, frontal, and occipital. These bones are highly strong, and last bone is parietal and frontal, because in the back side is partially injury are breakdowns, and because of foreparent are hand parent are also situated in there, and hand parent multiple nerves outside for the body according to nerve also. So blood clotting issue and another perceptions like injury, other things. So operation and another thing are usually to relate to that bone and that part. So according to morphology and the histology of human body, that part is so very big. And oxytocin bones is most strong, sir. They are situated on the forehead. So according to prosecutions, that is a murder if a particular intention. It is not a true, sir, because intentions is not intention is the most important thing in any criminal case. Without intention, any cause of actions are mistakes. Intentions, including intentions, cause of actions are also called as crimes. So that is a mistake, not a crime. So that point are accepted by the Nainital High Court. It is not a murder. By mistake that murder, because don't have any planning of the murder, because murder is a broad crime and a big crime. So very large planning also and multiple type of weapons, sharp weapons, guns, etc., etc. at all. But they are not present there in case. Just normally danda, sir. Danda is a burning of fuel, sir, for the making the cooking use, for the cooking use, sir. So that is a 2 feet, 1 feet also, like that. So intention is not clear. Intention are only fighting of the failing to the each other. Virendran also and Santanand C. Rawat also, sir. So intention is that incidents are not intentionally, sir. By mistake, that murder, that cause of action, I'm sorry, sir, not a murder. And according to prosecutions, appeal are present to the upper court with the additional evidence. It is not necessary, sir. Because appeals is a right of the accused and also another party, sir. Because Indian law is very liberated, sir.
So don't have any additional evidence. Additional evidence is a very good thing because of judgment is very easily to the court. Otherwise, additional evidence are not present there, so don't have any appeal. So it is not necessary because and FIR delay, sir. FIR written after 10 days. That is already police case, sir. Start to till the last day, sir. Because fighting and go to the hospitalized of the whole body bleeding also, sir. So they are already police case, sir, but don't have any member of side of prosecutions goes to a police station, written the FIR, do not, sir. So FIR are written after 10 days. Within 10 days, doctoral treatment also, sir, and operation are completed in 10 days. So they are questionable doubt doctoral negligence, that the death of Virender is death of medical negligence, is questionable doubt, sir. Because one person is a multiple injuries and very grievous injury according to prosecution, or they are 10 days survive in a hospital, or suddenly after 10 days is died, and by this goes to the police stations and written the FIR of such things. So what is doing in 10 days of the prosecution? And circumstances, evidences are not complete according to prosecutions. They are accepted, sir. And crime timing is most important. Do any crime, sir, because especially in a murder, sir, because timing is most important. In a murder situation, timing is divided into 3 parts, sir, according to chronology. First is morning time, sir, and evening time, and also night time. 3 times are most doubtable time because its visibility is nothing. Sun is rising, not a proper visual. Sun is set, not a proper visual. And night is completely dark, sir, so not so proper visual. So time is most important, sir. And property dispute issue. I don't know, don't have any descriptions written in a file, property dispute. Just only tutu meme in a marriage mehndi ceremony, sir. And what is intentions of orally fighting in a mehndi ceremony? Degree of argue in a marriage ceremony. Lower court are not considering that point. Only 14 prosecutions witness and another circumstances evidences are directly punished to the activity. Like imprisonment. One person is a whole life in the jail. What's in your life? What live a life? What experience of a life? They are born and dead. Death in a gap in a life is nothing. So, in multiple points is reasonable according to High Court and another thing so. And related to the case law, sir, Ahmad Shah and others versus State of Rajasthan 2016.
is for the evoking, prosecutions are talk abusing statements, sir. Complete file not talk to any abusing statement. Or during fight is multiple burdens, good and bad also in both sides, sir. So don't have in my client, sir. Ahmed Shah and others versus State of Rajasthan 2016 for involving exceptions of sections, not exceptions, sir, direct sections 101 of BNS. For request is must satisfy is namely, sir. It was a sudden fight. There is no premeditation, sir. Act was committed in a heat of passion and assignment had not taken by undue advantage, act in a cruel manner. Another case, sir, Manoj Kumar versus State of Himachal Pradesh 2018. Last paragraph, sir, of that case. We therefore hold that the appellant Manoj Kumar, Ranghil Singh and Surinder Singh are not guilty or guilty, sir. Not guilty because of not intentionally of that crime, or guilty is so because cause of actions done by that person according to human rights, so that are guilty. But intention, not intention based, they are not guilty, sir. And why is modified the convictions under sections 103, sir, of BNS? Accordingly, the appellant are sentenced to suffer is rigorous imprisonment for a period of 10 years. Same case, same sections and same situation, but problem is that body place of injury are not same. In case in a brain, in that case, Manoj Kumar cases in a chest, sir. They are that prosecutions are alive 11 days, sir. That are 10 days, sir. So intention are that cause of actions are not intentionally, sir. So I requested of the Honorable Court if I continue the punishment according to Nainital High Court and not consider it not a murder, sir. It is a by mistake cause of action.
Sir, the defense has itself given so contradictory statement that it also is very important for the court, for this honorable to understand why the accused is not only done murder but is a psychopath also. The first one being the first contention which my respected colleague has said, that the human body and especially the portion which is above the neck made up of very short of bones. No doubt, sir, it is made up of parietal bones and very short of bones, and they are very strong bones, sir. But it should also be appreciated that brain is considered as one of the most precious part of the human body and one of the most sensitive part of the human body. That is why, sir, brain has been structurized in such a way that where the brain has been considered as of basically three parts. First is cerebrum, second is cerebellum, and third is medulla oblongata. it has been the first point of condition which the prosecution wants to raise, that the accused has deliberately attacked on the medulla oblongata of the brain, which is considered by the scientists, 98% of the scientists, that it is considered as one of the most precious and the fragile part of the human body or the human brain. No doubt, brain is made up of parietal bones, but it is scientifically proven that no sort of bones is present in this part of brain where medulla oblongata is situated. The first point of contradiction which he has given. Second point, intention. Sir, my colleague no doubt beautifully explained that what is the role of intention in an offense. He beautifully explained the concept of actus non facit reum nisi mensit rea, which says that an actus reus, for to be an offense, must be accompanied by the guilty intention. But I would like to extend one contention, one of the most important contention for this court, at how the honorable court would determine the intention. Sir, the determination of intention is always by the conduct of the party. The court cannot go into the brain of the human body or basically inside the brain. It is the conduct of the human which plays a very important role to manifest the intention of the party. Sir, here I would like to submit that there has been skull fracture with a frontal wound on the left side and wounds with 34 stitches. Sir, I would like to bring attention upon this. 34 stitches is very much sufficient to determine that there has been voluntarily and intention plus knowledge also. It is the highest form of the state of mind which has been used in this crime. On the left side of the skull, extended from the mid of the left side of the skull, along with the coronal sutures of 16 centimeter. Sir, merely giving a blow of a lathi, or suppose if I say to you to the iron rod, will only give 4 centimeter and max 7 centimeter of the coronal sutures. But in this case, 16 centimeter of the coronal suture has been found by the medical examination. Here, the accused, I would like to extend my humble request that here the accused has not challenged the medical report, which states that the medical report is totally good and this is the medical report. It is also submitted that therefore the case would not certainly fall in the exception of section 300 of the Indian Penal Code, which is now Bharatiya Nyaya Sanhita. So I would like to also state one point. Sir, in third point, I would like to raise one important concern, that defense is doing nothing but beating around the bush. I am telling you why, sir. Sir, merely by saying that a murder is not a murder but a medical negligence, it is not right. Doctor has a duty to save the patient, and it is in the course of saving the patient that sometimes patient died. So it is of very immaterial statement that the medical negligence has taken place. And no, if one person is saving the life of second person, it may happen. It may happen in the treatment. Sir, the third point, which the fourth point, the defense has raised, that he has been admitted, despite having 34 centimeter of stitches, skull fracture, he has been admitted for 10 days, which raised the one important question. Sir, here I would like to request to note the case of Delhi gang rape case, where the victim Nirbhaya, sorry, I would not like to cite the real name out here, but Nirbhaya was totally and brutally raped by the 4 or 5 men, but still she has been admitted in the hospital for 20 days. Sir, it is of very immaterial value. If a person is having some sort of serious injuries, he can go into simple surgery, then coma, and then deep coma. Nirbhaya was in that deep coma, so it is totally immaterial to consider this statement. So I would like to request to basically make such sort of orders where these sort of pleading should not be accepted in this court of law, because this abuse is the process of court of law. Sir, the word cause of action has been retaliated multiple times by the accused. Sir, I would like to give, sorry, not in a disrespectful way, but cause of action only arises in civil cases, not in criminal cases, sir. If one person is filing a suit, so there can be a limitation period of 2 years, 4 years, 7 years, 12 years, 18 years and 30 years. It is called cause of action from the date on which the legal right has been, there should be an existence of the legal right, and the date on which the legal right has been violated. From that date the cause of action arose. In these sort of matter where the criminal things are concerned, sir, there is no any time limit. There are considerable number of cases where the rape has been taken into the judicial consideration after 5-7 years. The biggest example is #MeToo movement also, sir. So, sir, there is no any point of cause of action delay. Sir, merely 10 days of delaying the FIR. Sir, if one patient is getting admitted into the hospital, the family members of that patient will not play an important role to file the FIR. Rather, the focus is upon saving the individual life. So, sir, here I would like to bring attention of this court. 10 days delay in lodging the FIR and 10 days in the hospital. Sir, it is very much showing that the family members of the victim has focused upon that he should be saved. Sir, merely by saying that 10 days of delaying the FIR would totally, abrupt the case, sir, I don't think it is right, because, sir, despite the fact that FIR is being registered, it is not a reliable piece of evidence. So only by stating these sort of points which are on the circumference of the crime, I think it would not be accepted. These are the cases. Thank you, sir.
Sir, I would like to add some more points with the point raised by the defense counsel regarding the intention to kill. It is not necessary that intention to kill should be pre-planned or pre-defined, that they have intention, only then they have come to kill. When the accused has been attacking the victim, he has been asking for mercy, but he has not shown any. So he has continuously attacked on the head of the victim. This clearly suggests that he has knowledge that attacking on the head will cause death to a person, and continuously blow was being attacked on him. So it clearly shows that he has intention to kill, and when sudden provocation has been raised, that it was also subdued by the villagers, and there is no reason left for him to kill him. But at the night, when he has observed that his self-respect has been disturbed and he has been captured by the villagers for not attacking, he had planned that at night no one came to save him, so he had attacked. I would like to add some cases that in Pulichera, Nagaraju versus State of Andhra Pradesh 2006, the Supreme Court held that even a simple object is used, the manner of use and force applied determine whether it is murder or not. So it cannot be said that mere lathi cannot cause such injuries which has been inflicted. The injuries has also been supported by the PW11, Dr. Sanjay, I think. He has supported that there is a 34 stitches, 16 centimeter long fracture on his skull due to such injuries, and there is no altercation between such a cause that the fight occurs and after the 10 days. in such 10 days there is no another incident happened to him. So how can he claim that he has been injured by some other things? So it clearly suggests that such fractures had led to the death of the victim. So they cannot, it is not appropriate to take such defense. I would like to pray to the court that in the view of the facts and circumstances of the case, it is most respectfully prayed that this honorable court may be pleased to set aside the impulse judgment of the honorable High Court, restore the conviction of the accused under section 103 BNS as per the trial court's judgment, grant any other relief as may be deemed just and proper in the interest of justice. Thank you, sir.
So, don't have any misleading of the court by me. According to prosecution, Nirbhaya case is milestone case for the lady. In a rape case, sir. Nirbhaya case, FIR 2 and 3 are written by the local police station. Question is that times or that is responsibility of hospitals and prosecution's parties. Incidents completed that written FIR and do not go to police stations, not written FIR. So that is responsibility of hospital because that is a police case. So what are you saying of a high hospital reasons of the injuries? What is the reasons give to the hospitals by the prosecution's party? Because they are that case is completely police case, and hospital are not treatment or not a hospitalized do have any patient in a police case without investigation. Any danger situations, patients are admitted and directly call the local police stations. Don't have any procedures are done by the prosecution's party and the hospital management in a 10 days. So what is the reason to the hospitals of the prosecution parties? So that is a relevant question, sir. I accepted life is first. Protect the life of the Virendra by the family and another family members. But that is the responsibility of hospital management. They inform the police stations and telling that is a police case, Mr. Virendra Kumar in that situation. And medical's report are considered after FIR. So don't have any doubt of medical reports, sir. Only fixed time of a period of time, sir. Only operations. I'm talking about operations, sir. Operations is I can. I'm sorry, sir. Medically, doubtable point only operations, sir. Not another thing, sir. And according to prosecution, brain are exclaiming and misleading of the court. No, sir. With the brain theory and also I am telling about saying about the court. Sorry, sir, not telling. Saying about court. Human Physiology book written by Dr. Vandana Mathur and Dr. Nizar Kapoor. That book are applicable in MBBS, BDS, BAMS and BHMS student in reading it. And Human Anatomy written book written by Mr. Chaurasia. Mr. Chaurasia are very good surgeons from the Jivaji Medical College, Gwalior. That book is very authentic. 48 countries are teach in the anatomy for the MBBS and medical student also. And I'm very brief brain theory, sir.
So not I am talking about on that time because the timing is the most important of the code. But topic is starting by the misleading of the brain theory, matter and brain theory according to the prosecutions. Not so. Brain is basically a structure in a multiple layers. First is skin, second is the bone, third is the multiple coverings, three coverings. Parameter, dura matter, and endomatter. And in that covering, filling of the brain fluids. That fluid are protect the brain any grievous injuries. And basically, brain are divided into three parts: forebrain, midbrain, and hindbrain. Hindbrain is the most important part of the body, and highly grievous. Imagine to the highly grievous injury of the prosecution's party. Multiple injury, degree of the injury is vast. Patient is not goes to a coma, brain hemorrhage, don't have any blockage of the nerves. They are live and succeed in a 10 days. Multiple and highly vast graves. Yes, except that partially injury is that is completed 16 centimeter or 34 package also etc. But partially, sir, not any damage of the internal brain, sir. So they are not decided the degree of the injury by the medical report. So yes, medical report are questionable and operation period are also doubtable.
Sir, I would like to
And
explain
another thing, sir, I have no problem and not any argument of the related to the case because all questions are clear by me. Thank you, sir.
Sir, the final argument of the prosecution is that if the defense wants to raise any sort of contention, then the previous notice should be given. You are standing in the court of law where if you are challenging something which is not in the pleadings or which is not being retaliated by the Honorable High Court and Honorable Trial Court, the court should not first allow it. The second being, my colleague has beautifully explained that what is understood by life, how life is very much important for the individual. Sir, if a person who is having 34 stitches, who is having skull fracture, who is having 16 centimeter of bone sutures, sir, don't you think so that the prudent mind or the prudent conception of the doctor would be in order to save him, not to file the report in the police? Sir, if one person who is a patient who is having brain structures or brain fracture, something like that, the first duty of the doctor, irrespective of being victim, irrespective of being basically accused, it is the primary and prima facie a duty of the doctor that he should be treated with due diligence. Here, neither the High Court nor the Trial Court has played a very important role to challenge the medical evidences. Basically out in this side, sir. And as far as medical negligence report is concerned, sir, accused is also relying on the medical reports. If the accused is challenging medical report, he should not forget that on the basis of what things he is praying for the relief. He is praying on the relief on the basis of medical reports only, and no previous notice has been given. The first point of contention. So the second being, if reporting the case to police is very important, so there are various sort of cases where rape has been committed. Had this contention been allowed, then rape should be committed by the powerful people. The matter should be reported into the police, and then the treatment should start. I think it is not the right ideology. First, if the rape has been committed to someone, then the treatment should be given, and then the case should be registered in the police station. Hence, there is no any material argument which the accused has been submitted. Therefore, I would like to request to please pass the order in the favor of the prosecution.
Terminating argument by the defense is always applicable in the court and empowered by the court to the defense. His last argument is defense always. That case are not a rape case, sir. So again and again the rape case is not relevant to the defense here. And another thing, I am completely explaining of the case. And humbly request to the Honorable Court, minimize the punishment and continue the stay of the High Court also and the High Court.